advanced members will make a class a truly backward class and would more appropriately serve the purpose and object of clause 4. This discussion, let me kindly note this discussion is confined to other backward classes only and has no relevance in the case of scheduled tribes and scheduled castes. So this discussion is on creamy layer, whether the income of the class as a whole and the parameters and factors which would define as to whether the cord and the thread between the class and the individual and its backwardness has snapped or not. So these are the only two parameters where they exclude the discussion on scheduled castes. Otherwise, Indra Sahni nowhere excludes scheduled castes for the purposes of sub-classification. So, my lord, in fact, if your lordship would see on sub-classification, they positively, my lord, if your lordship would come straight away to 801, my lord, the question number 502, PDF 706, my lord. Where the question is framed whether backward classes can be further divided into backward and more backward categories. Mullah Sahib?
Yes.
And this backward, Mullah, includes SC/ST, because they say in Balaji it was held that sub-classification made by order between backward classes and more backward classes does not appear to be justified under Article 15.4. Article 15.4 authorizes special provisions being made for the really backward classes. In introducing two categories of backward classes, what the impugned order in substance purports to do is to devise measures for the benefit of all the classes of citizens who are less advanced compared to the most advanced classes in the state. And that, in our opinion, is not the scope of 15.4. The result of method adopted by the impugned order is that nearly 90% of the population of the state is treated as backward, and that illustrates how the order in fact divides the population of the state into most advanced and the rest, and puts latter into two categories of backward and more backward. The classification of the two categories therefore is not warranted. Article 15.4. This is quote from Balaji. Then they hold the correctness of this holding is questioned before us by the counsel for the respondents. It is submitted that in principle there is no justification for the said holding. It is submitted that even among backward classes, there are some who are more backward than the others, and that the backwardness is not and cannot be uniform throughout the country, nor even within the state. In support of this contention, the respondents rely upon observation of Chinnappa Reddy J. in Vasant Kumar, where the learned judge said, we do not see why on principle there cannot be classification into backward classes and more backward classes. If both classes are not merely a little behind, but far behind the most advanced classes, in fact, such a classification would be necessarily help the more backward classes. Otherwise, those of the backward classes who might be a little more advanced than the more backward classes might walk away with all the seats. Then in para 802, they say, we are of the opinion that there is no constitutional or legal bar. This was a specific question which fell from your lordships. To the state categorizing the backward classes as backward and more backward. Here they are comparing, my lord, two castes. Like in Andhra Pradesh, my lord, they are comparing goldsmiths and bades, who are stone cutters, my lord, to be a part of the backward class, but goldsmiths will always be more affluent than the stone cutters, my lord. So there, if a distinguishing factor is made between both of these, there is a rationale which is supported. Basically, my lord, the issue is that that exercise, as and when done, has to be taken to be whether it is done with the object sought to be achieved in mind, whether it is a reasonable classification or not. Now 803, my lords, may I have. There is another way of looking at this issue. Article 16.4 recognizes only one class, which backward class of citizens. It does not speak separately of scheduled castes and scheduled tribes, as does Article 15.4. Even so, it is beyond controversy that scheduled castes and scheduled tribes are also included in the expression backward class of citizens, and that separate reservations can be provided in their favor. It is well accepted phenomena throughout the country. What is the logic behind it? It is that if scheduled castes and scheduled tribes and other backward classes are lumped together, OBCs will take away all the vacancies, leaving scheduled castes and scheduled tribes high and dry. The same logic also warrants categorization as between the more backward and backward. We do not mean to say, we may reiterate, that this should be done.
There's a little confusion over here. Does that really apply to a subclassification of the scheduled castes and tribes, or is it really referring to only the subclassification of the OBCs, other than the...
My submission would be both. Because as your lordship correctly
said, that may not be a correct reading of Indira Sani actually.
My lords in fact said that what is the logic? If all the vacancies, leaving scheduled castes and scheduled tribes high and dry, the same logic also warrants categorization as they leave that aside only on two issues, not creamy layer and identification of backwardness. We do not mean when they discuss backward within the backward, they do not say we are not talking about scheduled castes.
Does that really whole discussion in the context of the classification of the social and educational backward classes, the OBC, referring to only the subclassification?
Whether or not it's a positive mandate, I leave it to your lordship to decide, because this judgment would most certainly be binding upon all of us. The only thing is there is no bar. They clearly and categorically logic all the vacancies, leaving scheduled castes and scheduled tribes high and dry. The same logic also warrants categorization as they leave that aside only on two issues. If there is a gap layer and identification of backward, we do not want when they discuss backward within the backward, they do not say we are not talking about scheduled castes.
Does that really apply to the context?
That is a rational criteria. That's what Indira Sani holds. That backward and more backward is a rational or not. It's a positive mandate. I leave it to your lordship's side, because it's permissible in law. Also, nothing in law bars. The only thing is there is nothing in law prohibits it. So if they state clearly and categorically, there's no mandate to do leaving scheduled castes. If the state chooses to do it, there's nothing. The same logic. That's also warrants categorization as they leave that aside only on two. If there is a gap layer and identification of backward, we do not discuss backward within the backward, then we will not straightaway come to Nagaraj.
Does that really apply to the context?
That is not, that's what is clear in category. That backward and in category. That backward and more backward is a rational and emphatic reiteration of sides. It's permissible in law. Also, nothing in law bar. The only thing is there is nothing in law prohibits it. So if they state clearly and categorically, there's no mandate to do leaving scheduled castes. If the state chooses to do it, there's nothing. The same logic. That's also warrants categorization as they leave that aside only on two. If there is a gap layer and identification of backward, we do not discuss backward within the backward, then we will not straightaway come to Nagaraj. That is a rational page 23 category. That backward and more backward is a rational and more backward is a rational and emphatic reiteration of sides. It's permissible in law. Also, nothing in law bar. The only thing is there is nothing in law prohibits it. So if they state clearly and categorically, there's no mandate to do leaving scheduled castes. If the state chooses to do it, the same logic. That's also warrants categorization as they leave that aside only on if there is a gap layer and identification of backward. We do not discuss backward within the backward. Just a couple of paragraphs which are relevant, because otherwise it reiterates the issue. That is a rational page 23 in category. That backward and more backward is a rational and more backward is a rational and emphatic reiteration of sides. It's permissible in law. Also, nothing in law bar. The only thing is there is nothing in law prohibits it. So if they state clearly and categorically, there's no mandate to do leaving scheduled castes. If the state chooses to do it, there's same logic. That's also what categorization. As we leave that aside, Thomas, if there is a gap here in identification of backward, we do not discuss backward within the backward, just a couple of paragraphs which are relevant, because otherwise we will reiterate the issue. That is not page 20 here in value, that backward and more backward is a rational and more backward is a rational and emphatic separation of sides. It's permissible in law. Also, nothing in law bar. The only thing is there is nothing in law prohibits it. So if they state clearly and categorically, there's no mandate to do leaving scheduled cards. If the state chooses to the Simon judgment, the same logic. That's also what categorization. As we leave that aside, Thomas, if there is a gap here in identification of backward, we do not discuss backward within the backward, just a couple of paragraphs which are relevant, because otherwise we will reiterate the issue. That is not page 20 here in value, that backward and more backward is a rational and more backward is a rational and emphatic separation of sides. It's permissible in law. Also, nothing in law bar. The only thing is there is nothing in law prohibits it. So if they state clearly and categorically, there's no mandate to do leaving scheduled cards. If the state chooses to the Simon judgment, the same logic. That's also what categorization. As we leave that aside, Thomas, if there is a gap here in identification of backward, we do not discuss backward within the backward, just a couple of paragraphs which are relevant, because otherwise we will reiterate the issue. That is not page 20 here in value, that backward and more backward is a rational and more backward is a rational and emphatic separation of sides. It's permissible in law. Also, nothing in law bar. The only thing is there is nothing in law prohibits it. So if they state clearly and categorically, there's no mandate to do leaving scheduled cards. If the state chooses to the Simon judgment, the same logic. That's also what categorization. As we leave that aside, Thomas, if there is a gap here in identification of backward, we do not discuss backward within the backward, just a couple of paragraphs which are relevant, because otherwise we will reiterate the issue. That is not page 20 here in value, that backward and more backward is a rational and more backward is a rational and emphatic separation of sides. It's permissible in law. Also, nothing in law bar. The only thing is there is nothing in law prohibits it. So if they state clearly and categorically, there's no mandate to do leaving scheduled cards. If the state chooses to the Simon judgment, the same logic. That's also what categorization. As we leave that aside, Thomas, if there is a gap here in identification of backward, we do not discuss backward within the backward, just a couple of paragraphs which are relevant, because otherwise we will reiterate the issue. That is not page 20 here in value, that backward and more backward is a rational and more backward is a rational and emphatic separation of sides. It's permissible in law. Also, nothing in law bar. The only thing is there is nothing in law prohibits it. So if they state clearly and categorically, there's no mandate to do leaving scheduled cards. If the state chooses to the Simon judgment, the same logic. That's also what categorization. As we leave that aside, Thomas, if there is a gap here in identification of backward, we do not discuss backward within the backward, just a couple of paragraphs which are relevant, because otherwise we will reiterate the issue. That is not page 20 here in value, that backward and more backward is a rational and more backward is a rational and emphatic separation of sides. It's permissible in law. Also, nothing in law bar. The only thing is there is nothing in law prohibits it. So if they state clearly and categorically, there's no mandate to do leaving scheduled cards. If the state chooses to the Simon judgment, the same logic. That's also what categorization. Quite right.
So if we come to the conclusion, of course, we are here to hear the other side, that Chinaya has wrongly decided.
As we leave that aside, Thomas, if there is a gap here in identification of backward, we do not discuss backward within the backward, just a couple of paragraphs which are relevant, because otherwise we will reiterate the issue. That is not page 20 here in value, that backward and more backward is a rational and more backward is a rational and emphatic separation of sides. Nothing in law only thing is there is nothing in law prohibits it.
What were the challenges
They clearly and categorically, there's no mandate to do it. Scheduled caste, if the state chooses to recognize the same logic, same, that's also categorized.
What are representing. So if we come to the conclusion, so we'll see what is the nature of their challenge.
Yes, yes.
Chinaya was decided.
As they leave that aside, Thomas, if there is a gap here in identification of language, we do not discuss backward within the backward, not just a couple of paragraphs which are relevant, because otherwise if any additional issues arise other than that is not based on backward and backward of fresh is a rational backward is a rational and only thing is there is nothing in law prohibits it.
What were the challenges?
There's no mandate to do it. Scheduled caste, if the state chooses to recognize the same logic, same, that's also categorized.
What are represented. So if we come to the conclusion, so we'll see what is the nature of their challenge.
Yes,
Chinaya was decided.
As they leave that aside, Thomas, if there is a gap here in identification of language, we do not discuss backward within the backward, not just a couple of paragraphs which are relevant, because otherwise if any additional issues arise other than that is not based on backward and backward of fresh is a rational and backward is a rational and only thing is there is nothing in law prohibits it.
What were the challenges?
There's no mandate to do it. Scheduled caste, if the state chooses to recognize the same logic, same, that's also categorized.
What are represented. So if we come to the conclusion, so we'll see what is the nature of their challenge.
Yes. As they leave that aside, Thomas, if there is a gap here in identification of language, we do not discuss backward within the backward, not just a couple of paragraphs which are relevant, because otherwise if any additional issues arise other than that is not based on backward and backward of fresh is a rational and backward is a rational and only thing is there is nothing in law prohibits it.
What were the challenges?
There's no mandate to do it. Scheduled caste, if the state chooses to recognize the same logic, same, that's also categorized.
What are represented. So if we come to the conclusion, so what is the nature of their challenge?
As they leave that aside, Thomas, if there is a gap here in identification of language, we do not discuss backward within the backward, not just a couple of paragraphs which are relevant, because otherwise if any additional issues arise other than that is not based on backward and backward of fresh is a rational and backward is a rational only thing is there is nothing in law prohibits there's no mandate to do it. Scheduled caste, if the state chooses to recognize the same logic, same, that's also categorized.
What are represented. So
represent about 43%. Our scavengers are occupying 81% of the
As they leave that aside, Thomas, if there is a gap here in identification of language, we do not discuss backward within the backward, not just a couple of paragraphs which are relevant, because otherwise if any additional issues arise other than that is not based on backward and backward of fresh is a rational and backward is a rational only thing is there is nothing in law prohibits there's no mandate to do it. Scheduled caste, if the state chooses to recognize the same logic, same, that's also categorized.
what are represented. So
represent about 43%. Our scavengers are occupying 81% of the
As they leave that aside, Thomas, if there is a gap here in identification of language, we do not discuss backward within the backward, not just a couple of paragraphs other than that is not based on backward and backward of fresh is a rational and backward is a rational only thing is there is nothing about there's no mandate for para 24 discrimination there is the essence of no mandate discrimination is the essence equality is violated rest of concept of para 24 discrimination is the essence of discrimination is the essence equality is violated rest of discrimination is the essence that's right discrimination is the essence equality is violated rest of discrimination maintain the essence One, three, three, six, the main judgment. 1, 3, 3, 6, the main judgment. 1, 3, 3, 6, Here, Lord Indra Sani is your lordship. I would want to clarify main judgment as to on what purposes and what is the further interpretation. 1, 3, 3, 6, which was protected by the rule of 50% was by balance and block consistently. Here, not Indra Sani is your lordship. On the other hand, in the present case, the question which we are required to answer what is the further interpretation. Whether various was protected by the rule of 50% was by balance and Article 16 here inspired by the observation. On the other hand, by the paragraphs 02 and 8, we are required in which this court has whether and Article 16 here inspired by the observation. On the other hand, by the paragraphs 22 and 8, we are required in 115 has whether Article 16 here inspired by the observation. In the said, on the other hand, by the paragraphs that states we are required in 115 has whether and We have